So, hi everyone, I'm Kath Dabrasini. I'm a partner in the Maddox commercial team, and I'm here today with my fellow partner, Rob Gregory. Rob has been advising a lot of our corporate clients on privacy and data protection compliance, areas of law that have come to the fore through COVID-19, with most companies changing their processes and managing staff working from home. Rob will talk about the privacy impact assessments and the Privacy Act and ensuring that data continues to be stored securely during this time. Welcome, Rob.
Thanks, Kath. Good to see you.
So, Rob, the pace of change seems to be slowing a bit as people adapt to the new normal. For me, the new normal means that many people are working from different locations. What does this mean from a privacy perspective?
Well, Kath, the most important thing that people need to understand is that there's been no relaxation in any sort of formal sense of the Privacy Act or the Australian privacy principles or the rules under them. What does happen is that, as you say, it's becoming a new normal. And what that also means is that there needs to be governance processes in place for this new normal set of circumstances across a range of areas. But in relation to privacy, it means that people need to be thinking about, well, how are we dealing with personal information that we've collected from customers or suppliers or other organisations that is different from what we've done in the past? What the Office of the Australian Information Commissioner would say, and I would agree with this, is that it's necessary to do either a formal or a quick privacy impact assessment. What does the new business as usual, the new normal mean that is different from what we've been doing in the past? And at a governance level, what are we doing to take account of that and change our processes and procedures to ensure that we're dealing with personal information in the way we had represented to the market or to individuals that we would handle their personal information at the time it was collected. So examples of that might be, for example, if a business or an organisation was to be making information available to health authorities for contact tracing activities, there are very specific provisions in the privacy legislation that enables that to take place, basically. But one of the things we would suggest is that if you're releasing information about people who've been coming onto a site or premises to health authorities, that you're keeping a record of what information is being released and the reasons why, that the reason why that is happening in terms of the request you'd received from the contact tracing team and the way the information was provided. But that should all be being done, as I say, in a framework and a governance process that means that it's happening by design rather than as an afterthought. The other aspects with a lot of people working from home, as you and I are at the moment, is that there's a higher risk of personal information being subjected to unauthorised access or disclosure or loss or misuse. And there's a very specific APP 11, that deals with the security and safety of personal information. So one of the things that organisations can and many are doing is putting in place arrangements for people working from home to make sure that, for example, that where they're printing out materials that contains personal information, they're collecting those printouts into a common place, and then they return to the office, that can be destroyed securely, those sorts of things. But once again, rather than relying on different people's interpretation of what is common sense, actually putting some governance and process around it.
Yes, I have seen our instructions that we're not really supposed to let any teenager children see any of the stuff that we might have printed at home or have access to any of our computers or files, etc. Even though they may be seen as low risk, these things are still very important.
That's right, and even in households where both of the adults are working, or all of the adults are working, they may well have different roles and occupations, and certainly organisations, and there's a risk of the personal information available to one organisation inadvertently being disclosed. So once again, practical steps to be put in place to mitigate the risk of that occurring, but also then in the context of the notifiable data breach regime we have now, where those inadvertent mistakes happen and perhaps personal information is being inadvertently disclosed, that a robust risk assessment framework exists for those notifiable data breaches. And then where there is a risk of serious harm, which probably won't be the case in many instances, but where that risk of serious harm is assessed as a result of that quick risk assessment, appropriate notifications to the OAIC, but also to the individuals affected are being made.
Okay, and perhaps just a quick recap on the consequences of a breach, about what sort of liability or fines are out there at the moment, and that, as you say, are still operable at the moment. So we need to keep on top of these rather than just letting them go at this time.
That's right. Well, look, all of the existing frameworks exist, and that includes the potential for civil penalties or fines. Normally, in most circumstances, the OAIC would take a what they call an educative and remedial approach rather than necessarily a punitive one. So where it's a mistake that has happened in good faith, and just because people are working in a very different way, you would hope that the risk of fines and civil penalties, those sort of more punitive measures, would be quite low. What is important, we've seen this very recently with a number of clients, is that when you're dealing with privacy regulators, if you can demonstrate that the lessons have really been learned in a genuine and deep way and not merely superficially, then that does give them confidence that a punitive approach isn't necessary. So that's certainly important. One of the other things I think it probably is worth mentioning is that as we sort of get through the initial phase of the response to COVID-19, many businesses are now thinking more about after Corona. What are we going to do in the future? What new products and services can we make available? So it'd be very important at that stage, as these new products and services are being considered, and given that a lot of them will be implemented in a much different environment, that adequate and quite robust privacy impact assessments of those new products and services are being undertaken. And by way of example, probably the best example in the market at the moment is the COVID Safe app, which the Commonwealth Government has released, and which is encouraging everyone basically to take up to enable contact tracing as a precondition to relaxing some of the social distancing requirements. Our firm and our team in Canberra, led by Catherine Armitage, did the privacy impact assessment of that COVID Safe app. You can see that online for yourself if people are interested. The Department of Health have published that quite transparently. And that's a really excellent example, I think, and as you'd expect, a very good example of a PIA done very well in very brief circumstances. So you can see that you can actually do these things quickly. They don't need to unnecessarily delay or be a hurdle that has to be overcome before a product or a service is released and implemented. But they can actually really help to dramatically improve the product. And in this case, I think you can see with the COVID Safe app, as people are realizing that they actually can have confidence in the way that the personal information will be used, it really is enhancing the take-up.
Yeah, that's very interesting. So you spoke earlier a little bit about releasing information when required to for health purposes, and then about keeping things confidential where you can. What other, aside from those sort of strict privacy issues, what other challenges are arising out of this new situation in the changing use of technology for businesses?
Yeah, so privacy is if you like, it's a subset of confidential information, but many businesses have much broader sets of confidential information, and traditionally, or typically, that's the information that gives their business a competitive advantage over their competitors in the market. So it could be financial information, it could be process information, could be insights that they've derived from their own analysis of otherwise public data, those sorts of things. So confidentiality is important at all times. Obviously, as solicitors, maintaining the confidentiality of our clients' matters is always paramount. But for other businesses, because it gives that competitive advantage, maybe it could be market and price sensitive information, and there's obviously obligations in the Corporations Act around the misuse of confidential information by officers of a corporation. For all those reasons, it's very important that businesses take a pretty robust view of how they protect the confidentiality of information. One of the most important sets of tools around that this time is around their cybersecurity settings. Cybersecurity can be a very difficult area for a lot of, particularly company directors and senior executives. They might have expertise and backgrounds in finance or marketing or human relations, or the actual business of their business, be it building or finance or whatever it is they happen to do. But cybersecurity is one of those sort of newer areas that many people don't have an in-depth personal understanding of in the same way as they might, for example, of accounting or finance topics. So once again, for those reasons, it becomes very important that there's a process. How are we satisfied as a group of directors or as a senior executive team that the people who are responsible for those cybersecurity functions are following a process, and it's not happening by accident or as a result of best efforts. It's actually happening systematically and by design. So there are a number of things that can be done. The Australian government and the Australian Signals Directorate has published a number of ideas and checklists that senior managers and directors can go through in terms of asking questions around how is our cybersecurity configured, and are we up to date, all those sorts of things that can start to, at a framework and governance level, give a degree of confidence and assurance that our organisation is meeting these obligations properly.
Well, thanks, Rob. It sounds like there's a lot of challenges here, both from intentional and unintentional breaches. So thank you very much for today. I'll speak to you soon.